Hello guys, welcome back to our channel Legal Nexus. In last video we discussed schools of jurisprudence and today we'll continuing from where we left off. So if you haven't watched the previous part yet, make sure to check it out. The link is in the description. Now let's dive into the topic. In today's video, we are going to discuss about historical school. Historical school of jurisprudence argued that the law is excretive form of social custom, economic needs, convention, religious principles, and relations of people with society. Law is found not made. This school did not support the theory propounded by the natural law thinkers that the origin of law is from superior authority and have some divine relevance. It followed the concept of man-made laws. It believed that laws is formulated from the people by the people means that the law should be according to the changing needs of people. It originates from the habits and customs of people which changes over a period of time according to their needs and requirement. Historical school arose as a reaction against the natural law theories. It also opposes the ideology of the analytical schools of jurisprudence. There were many prominent thinkers for this school. Montesquieu, probably the first jurist to adopt the historical method of understanding the legal institution, laid the foundation of the historical school in France. According to Montesquieu, it is relevant to discuss whether the law is good or bad because a law depends on social, political, and environmental conditions prevailing in society. He believed that law is the creation of the climate, local situation, accident, or imposture. He opined that law must change according to changing needs of the society. Von Savigny, known as the father of historical school, according to him, law was product of internal, silently operating force. It was deeply rooted in the past of a nation, and its true sources were popular faith, custom, and the common consciousness of the people. He believed that the law cannot be borrowed from outside, like the language, the constitution, and the manners of people. Law was determined above all by the particular character of a nation, by its national spirit. In all people, certain traditions and customs, through which by their continuous exercise evolved into legal rules. Only by a careful study of this tradition and custom, the true content of law can be found. Law in its proper sense is identical with the opinion of the people in matter of right and justice. Law is found and not made. Law develops like language which eventually grows. The organic evolution of law with the life and character of the people develops with the ages. Criticism on von Savigny theory. Charles Allen criticized Savigny's view that law should be found or based on the customs. Allen was of the view that customs are not the outcome of common consciousness of people, but they are the outcome of the interest of a powerful and strong of a ruling class. For example, slavery, which was recognized and prevailed in certain societies by the powerful classes of the society. Professor Stone criticized the Savigny's and opined that his theory ignored the efficiency of the legislation and planned law and social change. It overemphasized on the consciousness of people. For example, in India, the abolition of sati and widows' remarriage are brought into change because of powerful and effective legislation. Sir Henry Merritt, he was the founder of the English Historical School of Law. Savigny's view of historical school was carried forward in England by him. Main described development of law in four main stages. First stage, rulers are believed to be acting under divine inspiration and the laws are made on the commands of the rulers. For example, The ministers of ancient Greek. The judgment of king was considered to be the judgment of God or some divine body. King was merely an executor of judgments of God, not the lawmaker. Second stage. The commands of king converted into customary law. The custom prevails in the rulers or majority class. Custom seems to be have succeed to the right and authorities of king. In the third stage, the knowledge and administration of customs goes into the hands of a minority due to the weakening of the lawmaking powers of the original lawmakers like priests. The knowledge of customs goes into the hands of a minority class or ordinary class, and the ruler is suppressed by a minority who obtain control over the law. Fourth stage, the law is codified and promulgated. Main further opined the after the fourth stage the societies need to progress in order to further development in their legal structures. The societies which failed to progress beyond the code were termed as static societies, whereas progressive societies continue to develop their legal system with the help of principles of equity and legislation. Sir Henry Maine was a string supporter of codified and legislation. Criticism of historical school. Many scholars criticize this school of thought. Karl Marx devoted an entire in 1842 titled The Philosophical Manifesto of the Historical School of Law to criticize the historical school of law, calling it sole frivolous product of the 18th century. The fourth school of jurisprudence is sociological school of law. The idea of sociological school is to establish a relation between the law and society. This school laid more emphasis on the legal perspective of every problem and every change that take place in society. Law is a social phenomenon and law has some direct or indirect relation to society. Sociological school of jurisprudence focuses on balancing the welfare of state and inward of elite at the present as well as at any other time. The center of gravity of legal development lies not in legislation nor in the jurist decision but in society itself. Next, we are going to discuss about laissez-faire. According to Britannia Dictionary, laissez-faire is the policy of minimum governmental interference in the economic affairs of individual and society. Laissez-faire is the unrestricted freedom given to people by government. It is a governmental policy in which the government and law will not interfere in the economic matter of people. In the laissez-faire economy and the only role of government and law is to prevent any conflict and coercion against individuals like theft, fraud, etc. The sociological approach to jurisprudence, which resulted out of the change in the political shift from the doctrine of laissez-faire, the industrial and technological revolution, and finally historical school bringing into focus the relationship between law and social welfare state of modern century has attempted to study law as seeking social origin of law and legal institution, testing law as a given social phenomenon, and lastly judging law by its social utility. Montesquieu and Roscommon was the prominent thinkers of sociological school of jurisprudence. Montesquieu was a French philosopher and he paved the way of the sociological school of jurisprudence. He was the view that the legal process is somehow influenced by the social condition of society. He also recognized the importance of history as a means for understanding the structure of society and explained the importance of studying history of society before formulating the law for the society. In his book, The Spirit of Law, he wrote law should be determined by the characteristics of a nation so that they should be in relation to the climate of each country, to the quality of each soil, to its situation and extent, to the principal occupation of the natives, whether husbandmen, herdsmen, or shepherd, They should have relation to the degree of liberty which the constitution will bear, to the religion of inhabitants, to their inclinations, riches, numbers, commerce, manner, and customs. Roscommon was an American legal scholar. In his view, is that law should be studied in its actual working and not as it stands in the book. Theory of social engineering. Roscoe gives the theory of social engineering in which he compared law with the engineering. Engineers are required to use their engineering skill to manufacture new product. Similarly, social engineers are required to build that type of structure in society which provide maximum happiness and minimum friction. According to Pound, law is social engineering, which means a balance between the competing interests in society, in which applied science is used for resolving individual and social problems. Social engineering is the balancing the conflicting interest of individual and the state with the help of law. Law is a body of knowledge. With the help of law, the large part of social engineering is carried on. Law is used to solve the conflicting interests and problems in society. Realistic school is the last school of jurisprudence. Realistic school or realism is that school of jurisprudence which is more concerned with the scientific observation of law making and its functioning rather than the ends of law. The realist school of jurisprudence combined the analytical positivism and social ideologies. According to the realist school of jurisprudence, law is defined in terms of judicial decisions, not as a set of rules. Law originates from judges, so the law is determined by what the court do, not what they say. Hazel Hastrom is regarded as the founder of realistic school. The school is also known as the Asala School of Jurisprudence, a branch of the social school and left wing of the functional school. Realistic school of jurisprudence are classified into two types. American realist scholars not only learn from their own experience but they also watches and observed lessons from the judgments of their peers. Holmes, Gray, and Jeremy Frank are the main supporters of the American realist school. The second type is Scandinavian realist. Scholars relied on their own personal experience in this area. Oliver Cromb, Lord Stead, Rose, and Hagerstrom are the main exponents of the Scandinavian realist school. Features of realistic school denouncing traditional legal rules and concepts, focusing on what the court actually do to reach final decision. Law predictably depends on the specific fact before the court in a particular case, making it uncertain, supporting an emotive approach rather than a formal logical or conceptual approach, placing greater emphasis on the philosophical aspect as law deals with the human behavior and the conviction of lawyers and judges, opposing the value of legal terminology as a means of suppressing the uncertainty of law, evolving law based on its effect rather than its end. Let's identify the prominent thinkers of this school. John Chipman Gray. According to Gray, law is what the judges declare and it includes the rules that the judge of court laid down for determination of legal rights and duties of men. Laws made by legislators are dead words of the statute and courts put life into them through judicial interpretation. Carl Levin, he was a professor of law at Columbia University. He gave law job theory. He described the basic function of law as law job. Law is an instrument that is necessary in society, which is not comprised only of rules but also contain ideologies. Law has job to do within a society which the deposition of trouble case, a wrong grievance, a dispute, the preventive channeling of conduct and avoidance of troubles, the allocation of authority and arrangement of procedures, the organization of society as a also as to provide integration, direction, and incentive. Jurist method for task handling, so that's the essence of schools of jurisprudence. Different viewpoints, one goal, understanding and shaping the law. Knowing these schools help us see law not just rules but as a living system that grow with society. Thank you for watching this video. If you like this video, please like, share and subscribe for more legal insights.